the statutory provision that allows a citizen to make a complaint against a business establishment or location requires a sworn complaint. In this case, that did not happen. The testimony is clear that the citizen witness did not swear to the complaint. And it was my opinion that the hearing should not have proceeded forward from that point on, that it should have been sent back because that's clearly required. But nevertheless, the hearing went on.
The question is, I think it's critical that government be held to at least the same standard of compliance with the law as we as citizens are. If we violate the law, we're cited against parties for this requirement that there be swearing and affirmation. Anybody could challenge any bar anywhere in town and do so without penalty of perjury and just simply swear out complaints. I do not believe a man's living and the fate of this license consider that the government failed to do what the statute very clearly states. And this is not some long, complex deal. This is 1, 2, 3, 4, 5 lines long. There being no sworn statement and there being no affirmation, I'm concerned about the city facing very costly litigation that I believe we have a substantial chance of losing because we did not do what the statute actually says. This is not a technicality. This is an actual, it says sworn statement. And even if it was an affirmation, we don't have an affirmation, we don't have a sworn statement. I think that the better course of action simply is to refer this back to the committee, hold a lawful due process hearing, which we can do by simply voting to do so tonight, and then hold the hearing and not put the city in jeopardy of $30,000, $40,000, $50,000 worth of possible litigation, which is completely avoidable and which in the case of, 3 or 4 weeks, could be completely resolved.
Bear with me, I had a rather painful tooth extraction this morning, but I realized that being an alderman, I have a purpose to serve the citizens of Racine. Being on Public Safety and Licensing Committee, my commitment is to be here tonight.
Tonight, and I'm going to be voting no to deferral. Let's make our choice tonight. We can take the recommendation of the city attorney and give them until next Tuesday in order to seek legal recourse in the courts.
The 3 attorneys in this room that have been a part of this case, that are licensed to practice law in the state of Wisconsin. The city attorney, the attorney that represented the city in this case, and the defense attorney. 2 out of the 3 of them disagree that this one sworn issue is enough to keep this thing from going forward. And 2 out of the 3 of them say the appeals court will make a decision. And that it's likely that the worst case scenario is that the appeals court will send it back to the city and say, try it again. Worst case.
I signed the complaint, and he was asked by the other attorney, prior to signing, what did you do? And he said, I read the complaint. So not only did he help draft it, but he read what was written. He was asked if he raised his right hand, and he said he can't recall. He actually swore in a situation like I did with the lady here or not. But he said, you didn't swear to the complaint? And then the chief said, I signed the complaint as true and valid. Then in his testimony, he was asked by Attorney Rush, is this your signature? Yes. And he says, I don't recall raising my right hand, but was asked, based on the information, are these allegations false, malicious, or otherwise made up? And the police chief said no. So there's 2 types of problems you can have with a complaint. You can have a technical problem or a fundamental defect. Fundamental basically eliminates it and makes it you can't use it. Technical is just technical. It lets you proceed. As far as what I've, in consultation with the city attorney and reading through these things, I'm satisfied that the police chief gave us a true complaint. It'll cost us $5,000, I don't know, to represent ourselves if there's an injunction. but I know it'll cost another, I don't know, maybe 8 or 10 for a whole nother hearing.
Many due process hearings. Having been on the committee at the appropriate time, I'm also aware of the ongoing issues at Park 6. I attended the hearing and observed it, even though I'm no longer on that committee. I have to say, I'm not convinced that the city made its case at that hearing.
And when we talk about due process, and that's what we're talking about, due process of law. I don't think the law was followed and the due process was followed. And I strongly believe, and I know committee members don't like to hear that, but their minds was made up before the due process hearing.
Alderman DeHaan.
Aye.
Hart.
Aye.
Elding.
Aye.
Kaplan.
Aye.
Mack.
Aye.
Marcus.
Abstain. I don't think the
You can do that.
legal procedure was followed.
McCarthy.
No.
Mozo.
Aye.
Shakur. Shields.
No.
Spangenberg.
Aye.
Whitener. Aye. Weiser.
Aye.
Wisniewski.
Aye.
Coe.
Aye. That's that.
Now, before we have